Justice of the Division 4th Department. Hear ye, hear ye, hear ye. All persons having business to before this court will draw near, give their attention, and they shall be heard.
Good morning, everyone. Please be seated. Good morning, everyone. First case, 799, People versus Michael Rivera-Perez. Mr. Keem, good morning.
Good morning. May it please the court, Brad Keem for Mr. Perez. Are you able to hear me okay?
Yes, we are. Thank you.
Thank you. I'd like to get right to our plain view argument. We assert that the soft rifle case's incriminating nature was not immediately apparent, let alone established by probable cause, especially...
But just a minute, Mr. Keem, weren't they were looking for other things that could have been hidden in there, so it wasn't like...
Your Honor,
just an inadvertent, we're going to just look in here.
well, I think that it was. They were searching for petroleum products. They had already found a 100 gram and 368 gram jar. Petroleum products are not what you would normally put in a soft rifle case, let alone the shorts or a phone. It wasn't readily apparent that such items would be in a soft rifle case, and I cited to several cases that support that position.
Mr. Keem, though, looking at the search warrant, though, itself, it authorized the search of areas on or below the flooring, on or behind the walls, on or above the ceilings. They can even remove and or cut away any flooring, ceiling, or wall material for the purpose of accessing and or obtaining the referenced evidence. So, in this instance, if the officers were cutting away the flooring or the ceiling or the walls and they discover in plain view this assault rifle and magazine, how is that different than finding it in this soft case?
I think because it's a soft case, it would be, again, my argument is that it was readily apparent that petroleum jelly...
It's hiding something in the soft case. It could be hiding something in the soft case, or it could be hiding something in the ceiling or the floor.
Again, Your Honor, I suppose...
And that becomes apparent as soon as they cut away. The same becomes apparent as soon as they unzip the soft case.
I suppose that's possible, but our argument is that the case law would not support such a finding. If I could move on, the fine in this case, I understand that $1,000 is not something that the court might trouble itself with, but it is important to this defendant, this assigned defendant. He gained no profit from the offense. The fine was disproportionate to the conduct.
This defendant could have been sentenced to prison, correct? It was mandatory, but the court put it on the record why he shouldn't go to jail, correct?
Absolutely.
And it was a minimum fine and 5 years probation, correct?
Correct, Your Honor. Whether someone is incarcerated is far different than whether they are fined in terms of a financial burden that they have when they're already indigent. This is an indigent defendant that supports 2 daughters, his aging father. He makes $35,000 a year. The $1,000 fine, in my opinion, was unduly harsh, and we'd ask this court to reduce it.
We'll consider that. Anything else, Mr. Keene?
No, Your Honor. Thank you
very much. Ms. Mennicott?
Good morning. Catherine
morning.
Mennicott for the respondent. May it please the court, if the court has any questions for me, I can address it, or I would rest on my papers if there's anything specific.
No questions. Thank you.
Thank you very much.
Next case is number 800, People versus James Young. Waiting for Mr. Banaszak. Mr. Banaszak, good morning. Can you hear us?
I can, Judge. Can you hear me?
Yes, we can. Thank you. You can proceed.
Good morning, and may it please the court, Peter Banaszak for Mr. Young. I'd like to focus primarily on point 2 of our brief regarding the insufficiency of the evidence. The key deficiency here was that the proof failed to establish that the charged conduct occurred over a period of not less than 3 months. Critically, the prosecutor did not ask either the complainant or Rebecca Wilson when the conduct Mr. Young was accused of actually started. There was certainly evidence about when the complainant and Rebecca Wilson moved in with Mr. Young. However, that mere testimony does not specify the starting point of the conduct.
Counselor, you understand, the people are making the argument that that does meet that requirement because that's the time frame that's set, and with a young child that, you know, even at that age, I mean, it's not really a young child, but, you know, that's the time marker right there. What do you say to that, why that's wrong?
Judge, it's wrong because, so as Your Honor mentioned, there has to be some sort of a marker about when the conduct starts and when it finishes. This court indicated that in People v. Partridge, and I think I give some examples of that in a few cases in our brief. Specifically, I'll highlight People v. Hughes and People v. Thornton. So in People v. Hughes, the complainant indicated that the conduct started the summer before 6th grade. In People v. Thornton, the conduct started shortly after the complainant moved into a newly built residence. Here, we don't even have that. The complainant or Rebecca Wilson did not testify that this started shortly after they moved into the home with Mr. Young. They didn't specify that it started in the summer, in the fall, or in the winter of 2019 around any major.
Counsel, I think we've got that from the record regarding the absence of a start date. We do have, though, in the testimony of the child, we have this testimony on page 553, the transcript. How often would the defendant touch in a way that you didn't like? And she indicated like he did it a lot, like every week. Is there a way that the jury, depending on how the child said it, I mean, we're looking at the cold transcript, but is there a way that the jury could have taken that and had the sense that it was a very long period of time, in light of the fact that the start date could have been as early as July of the previous year until the police were eventually called in April of the following year? That based on the child's statement, that in and of itself, is that sufficient? Let me start with that.
Judge, I don't believe it is. I think that testimony certainly establishes the frequency with which the conduct occurred, but it does not establish the duration of the conduct. Something could happen a lot, something could happen weekly for a month, it could happen for 2 months, or it could happen somewhere in the neighborhood of 2 or 3 months. Our position is that the jury would have to assume or speculate that it was over 3 months, but it was not capable of drawing an inference of duration based on that testimony, coupled with the testimony about when the complainant and her mother started to live with Mr. Young.
I'm gonna add in one more thing, and that is all the testimony that we had about the different rooms. We have 5 different rooms, and the child was asked to talk about the sexual abuse in each of the different rooms. And some of the rooms indicated, more than once in one room or another, and more than one place within the room, I think, with respect to the kitchen, something. I mean, I appreciate it's difficult to get through the transcript. It must have been even tougher to sit through the actual testimony. But what about that? We add that on to what we've already talked about.
Judge, again, I think certainly establishes frequency, but one has to make an assumption that just because it happened repeatedly and it happened in different locations, it must have happened for not less than 3 months. I'm not aware of any case law that provides that a jury can infer duration simply based on frequency. Instead, this court and other cases have pointed to time markers. I certainly appreciate Justice Greenwood's point about the young age of the complainant, but that is already taken into account by the relaxed requirement about timeframes. But even taking that point, the case law, I think, is relatively consistent about some sort of time marker, even if that is relatively general. I think the prosecutor could have easily asked the complainant the question, did this start shortly after you moved in? Did this start around the time you started the 4th grade? Did it start around the time of the fall? Or anything along those lines that would have provided a shred of evidence establishing a time marker that would have allowed the jury to draw an inference of duration. In the end, here again, the jury could assume, the jury could speculate, but assumptions and speculation cannot be the basis for a legally sufficient case. In this case, the evidence on the sole count was legally insufficient, and our position is that that count should be reversed and the indictment dismissed.
Mr. Banaszak, I think we understand your argument. Anything else?
No, Judge, thank you.
Thank you very much. Mr. McCarthy, good morning.
Good morning, Marty McCarthy for the people. Congratulations, Justice Montour, sitting in the driver's seat. Addressing,
Hard to find the keys this morning, but go ahead.
well, Whalen likes to keep those hidden, so.
Yeah. Thank you.
Counsel's argument goes to legal sufficiency. When you consider legal sufficiency, you have to consider all the inferences have to be drawn in the people's favor. So any favorable inference that can be drawn in people's favor has to be drawn in people's favor. And when you consider what the testimony was, there are 2 bookends. The end is a few days before the defendant's arrest in April. In the beginning, the testimony was, it began after we moved in. The inference from that is it began after we moved in, which is in June. So they move in June, he starts touching her in June.
But it doesn't say, that's not in the record though. And I think in your brief, it refers to shortly, but it's not, there's no testimony as to whether it was shortly thereafter. It's just sometime after they moved in. And the whole point of this statute is this time frame. I mean, that's what we're talking about here. It's about the 3-month requirement.
So when you consider the words were after, right? There's no qualification, but I don't, in this position, when we're talking about legal sufficiency, I don't think the qualification matters because a jury would be free to infer that when she testified to after we moved in, it was after we moved in. That's when people normally talk, they don't talk about shortly thereafter. They talk about in terms of what did you do after it stopped raining? Well, after it stopped raining, I went outside. What did you do after you ate? I went to bed. It follows a sequence, if you will. So the jury was free to, when you consider not just the testimony regarding the fact that it began after we moved in, you also have to consider the frequency in which it happened. This wasn't like 3 incidents that happened over the course of June to April. This was something that was going on an ongoing, regular basis in multiple rooms of the house, multiple times in multiple rooms of the house. When you take all that evidence and you draw the inference was when she said it started happening after we moved in, the jury was free to conclude that that meant in June.
And they weren't living together before.
No.
Correct? I mean, so they moved into the defendant's house.
And the testimony was nothing happened before they moved in. So
Was there any testimony regarding how long the relationship was before they moved in?
there may have been, I just don't recall off the top of my head as to how long that relationship was.
The one thing that I didn't bring up with opposing counsel, we also had testimony from the child that they happened sort of at 2 different times. One would be on the weekends, which could be any time, but then also during the week, because it's my understanding that the defendant worked afternoons and evenings, but he had this break.
He had a break,
15-minute break at 8:15 p.m. where he'd come home for a snack or something. and that it would happen then also. Does that help, or does that make it, does that do anything regarding this analysis as to duration?
When you consider, yeah, I would say it definitely does help when you consider the fact that he was doing it in multiple different places, multiple different ways, multiple different times, multiple different circumstances.
Like every week.
Like every week. In order to accomplish all those acts in all those rooms at all those times, yeah, it would, you know. It goes to the frequency and pervasiveness of the conduct, especially when you consider she said it started after they moved in. So in that sense, when you consider the legal sufficiency, the argument as it relates to legal sufficiency, that's enough for it to get to the jury.
Well, I was just gonna say, but the testimony was that the last acts occurred in April 2020. So why isn't it just speculation, as your opposing counsel would argue, that the first acts could have occurred within a 3-month period before the April 2020 time period? How do we know it's outside that and complies with the statute?
So when you consider again the inferences that can be drawn, that was an inference that you could consider in the sense of if you were going to consider as a weight question. But when you consider it as terms of legal sufficiency, you have to give all the favorable inferences to the people when you consider legal sufficiency. And in that scenario, the level of activity that was testified to by the child seems pretty impossible to squeeze into a 1-month period when she says it happened a lot. If it happened a lot and it happened weekly, it'd be 4 times. And okay, let's extend it to maybe 2 months. Okay, it happened when she says it happened a lot and it happened weekly. Well, it happened 8 times. That doesn't sound like a lot. There were 5 different rooms. Okay, well, let's extend it out 3 months in that scenario. So going back from April to March to February to January. Okay, then you now are up to 12 times. You still have 5 different rooms and 2 different scenarios where it's either on the weekend or when he takes a break. And at that point, if you wanted to look at it that way, when you factor all the testimony together, that to me sounds like at a minimum it had to be 3 months. But the reality was she testified to the fact that it started happening after they moved in. And when you consider the frequency and duration of this, it makes a lot more sense. And the jury could easily conclude in that scenario and should have the ability to conclude that when she said it started happening in June, it happened with such frequency and duration, that it did start happening in June. You take her at her word. So
She didn't say it happened like after Christmas. I mean, let's just say that, you know, it was after we moved in. So my question is, how old is she?
when she moved in, she was at the end of 3rd grade.
Okay. So
So
that's
that's
7 or 8.
So you're talking about tender years, and that was what you were alluding to, and that's consideration for weight. In that scenario, we don't hold, and Mr. Banaszak referred to that doctrine, where the tender years doctrine, where we don't hold the child to strict time limit requirements because of the fact that they're young. In this scenario, as you said, at the time she was 7. So, any other questions?
Thank you, Mr. Card.
All right, take care.
Next case, 807, People versus Trent Goodrich.
Your Honors.
1 second, Mr. Bill, waiting for Mr. Baldina. Mr. Baldina, can you hear us? Mr. Blue.
Thank
you.
you.
Good morning.
May it please the court, Tyson Blue for Mr. Goodrich. Planning to concentrate today on the first point of my brief, alleging that the court erred in not letting Mr. Goodrich withdraw his guilty plea or sentencing him to more time than he had when the plea was entered.
At the time that the motion was made, there wasn't the contention was not that it was made because of the concern of an enhanced sentence, was it?
Well, the court had told,
Right, he told it, but at the
Mr.
time you made your motion to dismiss, it was, there was a claim that he was coerced by the prosecution into taking this plea. It wasn't that now I'm considering an enhanced sentence. I now want to withdraw my plea just because I did all these things. I failed to meet the conditions that you set at the time of I took my plea. Because I failed those, I'm subject to potentially 15 years, as the judge indicated that he would consider that if he didn't make those contentions.
Yeah.
That's not the claim that was made below. It was that, hey, this was coerced out of me. That's why I want to withdraw my plea. But now
Yes.
it seems as though you're making an argument that was arguably unpreserved.
Yes, Your Honor, would ask the court then to use its interest of justice powers to consider that, especially in light of the Sanchez opinion cited in my brief, which indicates that where a negotiated sentence doesn't seem appropriate, that the court may impose an enhanced sentence if it offers the defendant an opportunity to withdraw his plea. And that wasn't done.
Was there a need for further inquiry here? It seemed as though that even the defense counsel admitted that the conditions were violated, that he really didn't challenge the uncharged actions that took place in between the time of the plea and when he was picked up on a bench warrant. He didn't seem to contest any of that at all. It seemed as though the judge below had enough information where it wasn't necessary to make a further inquiry into the withdrawal.
Well, our position would be that at the September 14th appearance, when it was alleged that Mr. Goodrich had been arrested while he was awaiting sentence, first the court made reference to the arrests, and then the district attorney who was appearing that day characterized these new incidents as high-speed chases in Cayuga County and referred to pending felony charges in Wayne and Cayuga County. First of all, Mr. Sloan had indicated he wasn't aware of any new charges, and he also countered that the high-speed chases involved Mr. Goodrich's brother rather than Mr. Goodrich. So I'd say that since there's a difference of opinion regarding the nature of the charges and even the person alleged to have committed them, that should have been sufficient to trigger an inquiry into the basis for those allegations, which would seem to be required under the Oatley opinion that was cited in my brief.
Counsel, is there a distinction between, something new comes out in the PSR that I didn't anticipate, something from your past, something in your history, and oh, gee, I thought I could offer you this, but now I can't as the judge. Is there something different about that concept, which is what you had in Sanchez and Haslow as well, which you also cited in your brief, to the situation where you have behavior that occurs after the plea and you have a warning? I'm going to let you out. I'm going to set bail at a reasonable amount. I think the judge here said nominal amount. I'm going to let you out, but listen, you got to behave yourself. And again, we have that kind of language in the colloquy here as well. We have, when you get to page 15, 16, 17, judge says it, I think 3 times. You're going to be looking at 15 plus 5 if you get yourself into trouble or if you don't come back. Is there a difference, and should there be?
Well, I think there should be, again, specifically because in this case, there's a difference of opinion regarding the new allegations as to whether they even specifically dealt with Mr. Goodrich or not. There's also an implication about a pending felony in Wayne County made by the district attorney. And
if you look at those three conditions, don't get rearrested, cooperate with probation, and come back at time of sentencing. I mean, he violated all 3, correct? And he was, I think he was, as Justice Nowak indicated in the transcript, it shows that he was repeatedly informed and he repeatedly acknowledged the fact that, yes, if I do that, if I don't do these, I'm subject to an enhanced sentence or a greater sentence. You have that, the judge indicated that he would be bound by that. And arguably, because those conditions were violated, the judge was not then bound by that previous arrangement. Well, I think they offered 3.5 years. I think it ultimately was.
I believe so.
Plus shock. If you come back, I'm going to consider all these things. So he's had to have considerable benefits there by abiding by those three conditions, and you seem to violate those three specifically.
Yes, Your Honor. But also, in reviewing a brief to prepare for this morning's appearance, it struck me that the situation is also similar to that in this court's recent decision in People versus Taft, where the matter was sent back down for a new trial on the basis that the trial court made an insufficient inquiry into why the defendant wasn't present in court on the day of his trial, which would seem to indicate that there is some emphasis on the importance of inquiring into situations that arise during the course of the
I guess
case.
it also the fact that, well, you didn't cooperate with probation. You know, you ran to Georgia, you were arrested in Georgia, you served time in Georgia, you had to be extradited back here, all that. I mean, and there was never a denial by defense counsel or with respect to that. They had many opportunities to challenge some of that. I know you're indicating it maybe had been my brother or whatever might have been involved in that, but it seemed as though the judge wasn't necessary for him to make an inquiry with respect to the further allegations, since there really wasn't much of a denial on the fact that by defense counsel at that time. Would you like to add anything else, sir?
No, Your Honor. As far as the unduly harsh sentence argument goes, I'll stand on my brief on that.
Thank you very much, Mr.
Thank
Bowden. Mr. Valdina?
Thank you, Your Honors. Good morning, Chris Valdina for the People. Just to clear up some of the details. So he commits the crime, the underlying crime here, the robbery. Then while that's pending before he's arrested, he goes to Georgia, gets in the high-speed chase down there, gets prison time down there, gets extradited back here, pleads guilty to the robbery second here. The deal is 4 years unless you pay restitution towards the extradition costs before sentencing, and then he's warned multiple times by the judge, if you get arrested again, if you don't show up for sentencing, I'm not bound by the sentence, and you're looking at up to 15 years. Then he gets into high-speed chases in Cayuga and Wayne counties, and doesn't show up for sentencing, gets in the high-speed chases as related in the PSR. He's convicted of those crimes prior to sentencing. That's admitted at sentencing, acknowledged by him and his attorney. Says, I ran. So there's no request for an Appellate hearing. There's sufficient inquiry to establish that he violated the plea agreement conditions, and his motion to withdraw his guilty plea was on, as the presiding justice reflected, was based on completely different grounds, so that's unpreserved. So unless the court has any questions, I would rest on my brief.
No questions. Thank you, Mr. Valdina.
Thank you, Your Honors.
Next case is 808, the People versus Joseph Belstadt. Good morning.
Good morning. If it please the court, Tommy Uwano for appellant Joseph Belstadt, and I'll keep my comments to points 4 and 5 today, if I may. The Court of Appeals in Wigan said, how long is too long? We submit 24 and a half years in this case is too long and denies due process. Because this case revolves around a pubic hair found 11 days after Ms. Steingasser went missing.
Can I ask you a question?
Yeah.
Remember, this is a pre-indictment delay. Right.
Yes, it is.
And there have been many reasons cited for why it took so long. Your client was not incarcerated during this time.
Correct.
There's been no prejudice shown, correct?
Correct.
So I'm not so sure it matters that it was that long. If that's how long it took to be able to get all of this evidence evaluated, and things have been changing, and it has never been abandoned. They've been working on it all this time.
That would be very seriously contested by the defense There certainly should be a Singer hearing because there are contested facts, one of which is the hair, which I will address. And again, it's not newly discovered evidence. It's been around since day one or day 11. There are no new witnesses in this case. It could have been indicted in 1993. There weren't insufficient evidence in this case, and the scientific advances in this case were in 1998 when nuclear testing was made available. So this is very much like
Counsel, in the supplemental appendix, that
Yeah.
transcript that we have, the argument before the court. Defense counsel in that argument was claiming, it seemed to me, that the hair that was labeled as dissimilar by Erie County Lab. And I appreciate the argument that, well, Henderson didn't think it was dissimilar when he sent it to the Erie County Lab back in 95. But he's working on a lot of pieces of evidence. He sends it in 95, gets it back in 97, December 97, 2.5 years later, marked as dissimilar. The argument that counsel was making was that hair should have been DNA tested in 1998, along with a number of others. There was a lot of other evidence that was DNA tested in 1998. And in my reading of the affidavit from Henderson, is that was not included in 1998 because it had been marked dissimilar. You have a different view of that?
I don't have a different view, but that is not a reason not to test the hair in 1998. And the reason for that is this is a pubic hair withdrawn by force in the vehicle, the Pontiac 6000 of Joseph Bellstadt. It is marked by the lead forensic chemist as similar. There are similar traits to the 800 clippings they took from the vaginal hair. It goes off the Erie County Lab and it comes back as dissimilar. In 1998, they send hairs. Why wouldn't you send the hair that was brought out by force, found in the driver's side floor mat of the vehicle of the suspect? That is the first piece of evidence that should have been sent out. It was labeled again by the lead chemist as similar. Similar by one chemist, dissimilar by another. They forcibly ripped out pubic hair, test it.
But Henderson says that it was based on his subsequent training. It's the opposite of what you're saying. You're saying that they knew this back in 93, 95. They're saying, no, I was trained all these years later and the science has changed. And the training has changed. So now that is why that's why it's different now.
That is
what's your response?
I apologize. That is exactly why you need a Singer hearing, Your Honor. Because what Henderson is saying is that the science has changed. Yes, the science had changed for nuclear DNA testing in 1998. In fact, the Niagara County Lab had the power to nuclear test in 2001. So in terms of his training catching up, the fact of the matter is there is no case law that says that he didn't have the skill set at the time, with all due respect to chemist Henderson, to go back and have the hair reevaluated in 98 when it should have. They could have sent it to a private lab, which they concede. They could have sent it to the FBI, to someone who absolutely has the skill set, and gone back over this critical piece of evidence. Which is why I can't, quite frankly, for the life of me, understand why there wasn't a Singer hearing in this case. Because all of that, what the court is saying, are contested issues of fact. We would bring in our defense experts that would say it doesn't require any advanced skill set to identify trace evidence, a pubic hair. It's done under a microscope. We would bring in experts that would say in 1998, nuclear DNA was available. And that should have been tested in 1998. Actually, the hairs went back. There were hairs looked at in 2004. Again, this critical piece of evidence, the only one indicated similar in this case, doesn't go back. In 2013, they asked ADA Holly Sloma to again reevaluate the evidence. Again, the pubic hair forcibly withdrawn from a body, found in the Pontiac. Marked as similar and not
fake here. That, according to Henderson's affidavit and everything else, there's no bad faith that would require the Singer here.
Judge, there's no bad faith. Well, we think there is bad faith in the delay. There certainly isn't good cause here. And I believe the case law is there.
So we have to look at.
Yeah, you need to look at good cause. As Michelle Bergevin said, the defense attorney, you could go on for weeks contesting that which is in this affidavit of Henderson.
I think we understand.
Yeah, we dispute almost all of it. And I would say that it's strikingly similar to the Singer case. The Singer case was a murder case in a car with blood and pubic hair with a homicide, 42 months. 42 months, and they sent it back for a Singer hearing. Now, what we do know is that Singer reaffirms Taranovich, which gives us the 5 factors as to whether or not due process was denied, one of which is the extent of the delay. There's no case law supported by the people that would show that 24 and a half years is okay. The longest one they show is 19, and that was an insufficient evidence case.
That's the Rogers case, right?
What
That was the Rogers case,
It's
right?
the Rogers case, correct. And what we do know is in this extent of the delay is that they talk about the longer the delay, it skewers the fairness of the system. You are entitled to prompt justice. You cannot say because I didn't have the skill set, because I had multiple opportunities to test his hair and chose not to, or wasn't given the discretion by the district attorney's office, or didn't have the resources. That's not the case law. You are entitled to due process. You are entitled to prompt justice. And what it talks about is, again, it skewers the entire fairness of the system.
Yeah, understand that.
Thank you, Brad. And secondly, the reasons for the delay, which is what Your Honor talked about. There are reasons for the delay that are seriously contested issues of fact. That certainly being the pubic hair. And again, I would go through the fact that in 1998, they had the science, they submitted it, they should have sent.
In an optional way that they did it, but there was no bad faith again. There was so much that had to be sent out. There was so much that had to be done that couldn't be done right within their own lab, et cetera. And I think that Henderson's affidavit addresses all of those issues.
Henderson's affidavit, in the defense opinion, is self-serving, and it raises more questions than answers.
Right, and that's what we have to look at.
And that's why, again, I can't imagine why the people didn't consent to a Singer hearing or the court order it. And again, they rely on Decker and Rogers, which Justice Montour referenced. And those are cases where there was insufficient evidence. What is critical in this case, and is in the people's brief, is that what they say is certainly the jury would have liked to have seen a piece of physical evidence. Well, Wiggins says you can't delay a case ad nauseum just to strengthen your case. This is a red herring. In 1993, we knew from this. No, I'm sorry, Judge. This is a different point, if I may. Thank you. There were 3 admissions by the defendant. She was in the car. A police officer saw her get in the car. Another witness saw her get in the car. So what the pubic hair establishes is that Steingasser was in the car. We know that. That's an unnecessary fact to prove this case. And the people concede that there was enough to indict in 1993. So for that matter, Your Honor, this case should be dismissed for the delay, or at the very least, a Singer hearing. The other reasons they give are costs and resources and things like that. None of that is in the case law. None of that's permissible. We are talking about a constitutional right to due process. You cannot say because the 2 prior administrations did not give the resources or give it the priority that my client gets denied due process and a fair trial. Kudos to DA Watazik, who did give the resources to prosecute the case and did give the resources to go through it, but that doesn't excuse the decades that the other district attorney's offices did not give the resources. Should we say someone should be denied due process for 20 years because they had to wait that long for a district attorney to do the proper job? I don't think so. One of the other things is that, and why we need a Singer hearing at the very least, is that this decision was made by the court without being submitted to raw data. This is all about the science. This is all about was there a good cause for the delay? And the court conceded that it didn't have the science. Well, I don't think you can make a decision on a Singer hearing without at least having the science before you. The nature of the charge is homicide. We all know that the statute of limitations doesn't control here. Due process does. And that the nature of, there are many cases, Wiggins, Romero, Rogers, Decker, where homicide cases were past the statute of limitations. And that does not control here. But what does control is that it completely erodes the confidence in the criminal justice system. And again, skewers the fairness of it when you wait a quarter of a century to charge somebody when you could have charged them in 1993. You could have indicted. The people concede that. The length of pretrial incarceration, again, even though he was not incarcerated early on, they searched his house, they searched his car. He was in 1994, they asked for compulsory DNA, which the court granted, and it was in the media. So as they say in the cases, although you weren't factually charged, you were actually charged. Impairment to the defense, there was a 13-page affidavit submitted by defense counsel Bergevin, where she gave multiple reasons for the impairment or prejudice to the defense. She went on to say that she could go on for weeks. The case law holds that the longer the case is delayed, the greater there is a prejudice. Prejudice is presumed at that point. That's what the Court of Appeals says. And again, just to show you how much we think we've been prejudiced.
Right, I think we've read all that and we're familiar with the paperwork.
Unless there's any questions,
Mr. Romano, thank you so much. Appreciate your.
Thank you very much.
Mr. Seaman?
May it please the court, Brian Seaman for the people. Going directly to the Singer hearing, this court has held in the Rogers case and in other cases that when the lower court has an adequate basis and there are not contested issues of material fact, that there's no need for a evidentiary fact-finding hearing to determine the Singer issue. And that's exactly what happened in this case.
Isn't it been beneficial here, at least to the defendant here in this instance, who's been waiting around 25 years or 24 years to be charged, to at least have an opportunity to cross-examine Henderson on his affidavit? I mean, it seems that you got a paper affidavit. I did this, I did that, took all this time, I did my training. And all of a sudden, there's been a couple administrations, they gave me a little extra time to do so. I mean, that's before the court, but there's not an opportunity to question him, cross-examine him on any of those contentions that he made.
So it could have been done, Judge, and that would have been possible. But the question was it necessary to do it? And there were over 60 pages of written submissions. The court asked for additional submissions or factual submissions. They were under oath or affirmed. That was all before the court. And what didn't rise up from that is a material issue of disputed fact. So Henderson had everything that he said. And then Mr. Ioano has argued today that, well, we would have had experts that said different things. Well, there was nothing before the court. There was no affidavit from a defense expert saying something different. Nothing was submitted that set up a fact issue requiring the court to bring in witnesses and take testimony. In fact, the judge credited all of the information that was provided to the court by defense. And she said, even though all of this stuff, and then she did the other Taranovich factors and she weighed it. So could we have done a hearing? Sure, we could have, but there's nothing that says that just to give a chance to cross-examine is an appropriate reason for a hearing. There has to be a fact, a material fact that's disputed that the court needs to hear testimony about to make a determination on. And I would argue that that didn't happen here. And I still haven't heard what would be the material fact that we would do, if we had a Singer hearing today, what would it be? What would be the material issue of disputed fact that we'd have to take testimony to find out? And I don't know what that would be, even after reading all of the briefs and hearing the argument here.
Well,
today.
your opposition said that one of the things that's disputed is that the DNA testing couldn't have been done back then.
So I don't believe that is disputed, Your Honor. We agree that somewhere between 1998 and 2006, that were advances in DNA technology that would have allowed for a single hair with root tissue to be tested for DNA. We don't dispute that. There's no need for a hearing to determine that. That's true. And so, but the question is, well, why wasn't it done? And we can look at it now in hindsight, say, well, this is her pubic hair. Why didn't you test her pubic hair? We did not know it was her pubic hair. And in fact, using the best available forensic techniques at the time, all that was available was visual examination.
Well, so what's the effect of Henderson's statement that he learned more as time went on? The training got better,
That's exactly what happened, Your Honor. When Mark Henderson found that hair, he had no training, not minimal. He had no training in hair identification. He just looked at it and said, oh, this kind of looks like her pubic hair. So he took it to a person who had excellent credentials. He had all the training, and that was the individual at the Erie County lab. He had all the training, and his trial testimony bears out. He has examined thousands of cases of hair identification. He looked at it and he said, this looks dissimilar. And that's all there was then. It's either similar or dissimilar. You cannot go further and say it's her hair. It was dissimilar. So it was on that slide, on a microscope slide, and it was put aside with other evidence that probably is not probative. So when we say, well, that could have been tested, you would not test a hair that an expert has said is not hers when you're only able to test a few at a time. And that's how it was back in 1998. There were some hairs sent out for DNA testing.
Right. And this isn't a situation where 10 hairs were recovered from the car. This is a situation where thousands of pieces of evidence were being analyzed.
When the police went and took the vacuum of the car, they came back with 30 vacuum bags. And when I say vacuum bags, it's the kind of bag that when you run a vacuum and you see everything that comes, that's what it was. But they were taken into a particular chamber and safeguarded. Hairs, fibers, dirt, all that stuff was in those bags. And they spent thousands of man hours going through particle by particle. And now we look at it in hindsight, so it was the pubic hair, that was the important thing. But they didn't know that. They spent hours and hours and hours going through looking at fibers. Did the fibers from the victim's jeans match fibers in the defendant's car? Did the fibers from the car trunk match fibers that were found on the victim's clothing? Things like that. They spent hours and hours. They didn't know that this was the piece of evidence until they did the DNA testing and found out that this is the piece of evidence. So it's a hindsight argument saying, well, you should have done this because this is the crucial piece of evidence, except it wasn't known at that time. And an expert said it's not.
And it seemed as though the investigation was continuous. It seemed there may have been a lull here or there. I'm not even say a lull, but where maybe there wasn't enough resources dedicated to it. But it never really was put in a box, and they never had to dust it off and let's try it out now, like many cold cases.
That's absolutely right, Judge. In this case, we were actually, if you look back at it, we were at the doorstep every time there was an advance in DNA technology. We were sending out samples in 1994 and 1995 for DNA. That was in the infancy of DNA. We were trying to get things tested for this case. In 2001, Erie County came online. We're Niagara County. We were knocking on their door immediately. And in 2002, they were already doing tests on this case. 132 samples eventually were tested for DNA by the Erie County lab on this case. Far and away the most that's ever been done in any case in my county. It's a case that always had a district attorney assigned to it, always had a police detective assigned to it, was constantly being monitored and looked at whenever there was a new type of technology and a new type of forensic technology. And eventually they even started to go back and look at the things that appeared that they weren't probative, like that hair that they were told was not Mandy's hair, but it was.
Anything else?
If there are no further questions on the other points, I will rest on my papers.
Very good.
Thank you, Your Honors.
Next case is 809, the matter of Martha Cronin versus Marcus Cronin. Mr. Denman, can you hear us?
I can hear you. You hear me okay, sir?
Yes, whenever you're ready.
Good morning, sir. May it please the court. I would like to start my argument by stating unequivocally, it is not Mr. Cronin's position nor my argument that a diagnosis of Huntington's disease disqualifies a parent from being an award of custody. We don't argue that. We've never argued that, and we don't intend to argue that. But in this matter, there are some inconsistencies in the decision itself and with the findings of fact that were made by the court. As you can see from the very short table of authorities in my brief, this is primarily a factual issue. And I'd like to point out the probably, I think, one of the most important parts is where the judge says in his decision, right before moving on to the orders, both parents are on nearly identical footing for their fitness. Right. So basically, we've got equal case. We've got two equal parents, yet the judge, without citing any factors or any reasons, determines, but it's in the child's best interest to place her with the mother. The only real justification that the court gives in its decision is that the mother is experiencing no symptoms at this time and is healthy, which
Counselor, didn't the court point out there's some credibility issues that the court pointed to in the father's testimony? It was more than just the mother's situation. Wasn't the father's also?
Absolutely. But those are still factual issues that were discussed, and the court did finally come down on the side of it's equal. It's 50-50.
Right. There's no question the court said they're both loving parents and they're both capable, but the court had to make a decision because in this case it didn't make sense because the child is now of school age, right? And it had to live one place or the other.
Right. And that's correct. The child needed to start school somewhere. And we don't.
And our is sound and substantial basis in the record. So we could even basically agree with you that maybe the better result would have been for your client, but that's not really our standard review here, is it?
No, but there needs to be a basis in the record. And, you know, in the case I do cite, the matter of Louise E.S., it lists some factors. And one of which is the stability and the effect of change. And we do know that, again, we're not saying that a parent with Huntington's disease is incapable of being awarded.
Weren't there some factors, though? The child attended preschool where the mom lived, correct? And established friendships, perhaps, that would continue through kindergarten. And there was also extended family that were also near the mom, correct?
Correct. But there's also extended family near the father. And the fact is, Huntington's disease is progressive. It's undisputed that she has it. Ultimately, she will be unable to care for this child.
I thought you weren't gonna argue Huntington's disease.
I said not automatically, but I am going to say in a 50-50, and this is the other part of that. I do agree.
At that time, then, if it develops and it becomes more debilitating for the mother, wouldn't there be a chance then for you to make a motion at that time for change of custody or change of residential?
Absolutely. But in this case, the judge didn't address what factors he was basing it on. He never said the mother is in the best interest here. He appeared to just say, well, the mom's in good health right now, which even the judge's statement that the mother is experiencing no symptoms right now. That's not consistent with the testimony that was at trial. But other than that, the judge said, okay, both parents are equal. And while I'm not saying, and as I started off, a parent with Huntington's disease is not disqualified, but it certainly could be a factor.
Well, it seems as though, yes, maybe it's a factor, but there was a witness who came in and testified that she's doing well. She's working with Strong Memorial. It's a Center for Excellence for Huntington's disease. It appears as though at this point in time that there's no issues with her as far as taking care of the child.
But why does that doesn't make it better? That doesn't establish that it's in the best interest of the child to place her there. Might be in the best interest of the mother at this point, but that doesn't establish the best interest of the child. All of the factors, the child's preferences, they weren't addressed at all in the decision. There will be change. We know that. And then all the other factors, the judge comes down equal on.
Counsel, just in case counsel for the mother brings this up, we had this issue about the father representing in February of 24 that the child had been in preschool. And then it came to find out that the child actually wasn't in preschool, that the preschool had canceled or had rescinded the offer for the child to go week on, week off. Right or wrong, doesn't matter. But the fact that there was like a misrepresentation made in the petition that the father knew about but made it anyway. Do you have a response to that?
It wasn't cited. I did not I was not at the trial. I did not participate at all. But certainly if there was a question as to whether that was a part of the fitness or should be included as in the fitness of the father to assume custody, it should have been addressed at trial. And the judge didn't cite that as, any kind of a factor. So, is it an unfortunate fact out there? It possibly is. I think that it could have been developed more. I think there's a lot of facts that could have been developed, greater at trial than were. And I guess the ultimate argument, and I'll end with this unless there's questions, is the judge came down on the side that this is essentially a 50-50 case. We have two parents that are equally okay. However, and again, I'm not saying it disqualifies, there is this Huntington's disease out there. And the fact that it is degenerative, the fact that it will lead to, unfortunately, and trust me, this is a tough case. This is why I would never, ever want to be a family court judge, because this is a tough case. But unfortunately, this disease will progress. And, should that have been a factor? And I think it should have been, and Mr. Cronin believes that it probably should have been a factor that, again, with everything else equal, should have tipped the scales towards custody with the father. So if there's no further, I'm sorry.
Thank you, Mr. Zimmerman.
Thank you.
Mr. Muldoon.
May it please the court, Gary Muldoon for Martha Cronin, the mother. The father's brief makes two arguments, best interests and also criticizing to the admission of expert testimony. And the father's brief also does not address one issue that this court has asked on oral argument. That is the candor of the father regarding the child being at the pre-K in the Rotterdam area. When it comes to best interests, there were 5 witnesses who testified. 4 of them were for the mother. The father alone testified. He didn't bring in his parents who are apparently actively involved or anyone else who might testify on behalf, nor did he bring in an expert witness to counter what the mother's expert witness, Amy Cheshire, brought out. So that's an important thing that makes, I don't think this is a tough case for a family court judge. the information that the mother provided was exemplary of what goes on at the Geneseo residence and with the pre-K that she is involved in, Pride and Joy, and of her her having Huntington's disease. The father brings his own testimony, and unfortunately, his testimony is suspect. His testimony, there is this inconsistency that's been brought up of whether the child was actually attending pre-K Maple Leaf in the Rotterdam area. So it's not that difficult a case here. The other thing that the father's brief brings out, and it wasn't really mentioned on oral argument by opposing counsel, is that the challenging the expert witness. This was Amy Cheshire, who had 2 master's degrees, had spent 2 decades with the family, and had provided wonderful background evidence that
that she was testifying outside her expertise. She got her master's degree from the University of Southern California, right?
Well, I haven't
Never heard of a Trojan, but I'll
Be a problem.
Okay.
That's my alma mater.
You're looking at him like, what?
Anyway, I haven't known. Anyway.
He's a Bruin fan. No.
Oh,
So her testimony was an exemplary kind of testimony that a court needs to have.
But his counsel didn't object to her opinions or explanations. I mean, so it's unpreserved, isn't it?
He objected 10 pages earlier in the transcript.
Right.
And with a general objection. So I submit that it is an objection that was unpreserved. If the court doesn't have any questions, I'll submit.
Well done, thank you.
Thank you.
For Di Pasquale.
May it please the court, Andrew Di Pasquale, attorney for the child. So the first issue I wanted to address has to do with the parties were both on equal footing. That was a central focus of my brief. And in the court's decision, they did mention, and I quote, a strong and bonded relationship with the extended family in the Geneseo and in the Geneseo area as being a factor in their decision. And then I believe that in the Rotterdam area, the family members were a bit older. That is my recollection. In the record, I believe that's discussed in my brief. I think that so I just wanted to, I wasn't planning on talking about that too much. I wanted to talk about the speculation about Huntington's disease.
Let's talk about that because that's really
okay. Yeah, it's because
didn't the family court judge though find basically that she's okay now, that even though she has this disease, it's not affecting her right now.
That's correct.
And as the justice presiding pointed out earlier, that if there's a change later on and this progression that is being anticipated, that's when a modification petition could be brought. And is that your position as the attorney for the child? Basically?
It is. And in fact, the petition was brought after the fact here. There was a trial that took place over the summer. So that, I think, buttresses the point.
So what happened there?
That was, there was a trial order of dismissal that was granted. So
there was a petition for a change of circumstance, modification petition for a change in circumstance, saying that her condition had worsened. Is that what we're hearing now?
That's
for the first time.
Based on my conversation with the attorney for the child at the trial level,
Right.
yes.
And it was obviously brought by dad,
It was brought by dad.
saying that mom's medical condition changed.
The AFC didn't provide that information. How she phrased it to me was that it was basically the same trial over again.
How does that affect this appeal?
It doesn't, in the sense that this is still the active order. But it would, I think, support my argument that speculating about someone's health in the future is not a basis for a best interest determination. I think we have to keep our focus on what is in the record, and what's in the record is that we have a child who was going to Geneseo who has extended family, who liked where she was going to school. And so I think to upend that, especially in light of the the credibility issue that came up about whether or not she was even going to school in the Rotterdam area, which, that was put in a petition, comes out on a cross-examination, that's actually not taking place. So I think that the court has found a substantial basis in the record.
Very good. Thank you so much. Next case is the matter of Justice G, number 810. Ms. Whiteside, good morning. Can you hear us?
Yes, I can.
Yes, we can hear you. Very good. Ms. Yoon?
Good morning, Your Honors. Jane Yoon for the mother. Because there was no evidence here at the fact-finding hearing on the petitioner's direct case that the child had either an actual injury or physical harm or any impending harm, the trial order of dismissal motion should have been granted. The Court of Appeals and this court, not very long ago in the 2024 case of matter of Justice H.M., has read the Family Court Act statute to require that there be proof of actual harm or imminent harm. And imminent harm is not just speculating what might happen. There's got to be something more than just a hypothetical suggestion that a child could be injured.
Well, it's not hypothetical if the mother's saying she's going to shoot people, right? So.
Well, I think that's got to be taken into context, right? There's evidence that the mother even testified at, when it was her time to testify. And I'm again focusing on the petitioner's original case with respect to point 1 in the trial order dismissal. But the mother even admitted she has a tendency to get excited or excitable, and she may not have the best impulse control. I think
Is that when she gets asked to leave her various housing that she's going from one location to another?
There is that evidence, but again, the focus isn't about the housing. First,
Isn't a child present during those altercations a lot of times and witnesses those and finds them somewhat disturbing, and that can potentially harm the child?
Well, it's not clear that the child found those disturbing. There is evidence, I think, that the child was present for those, but I would argue that just as in simply witnessing domestic violence instances doesn't mean that the child is in harm. You still have to establish the harm. And if we're talking about, I think there's no dispute that there was no physical harm to the child. So if we're talking about mental or emotional harm, it's defined in the statute as being substantially diminished. And there's no evidence of that in the department's initial case that the child was anything but a 5-year-old child who certainly has endured some troubling circumstances, but there's no evidence that she was mentally incapacitated or emotionally incapacitated beyond the normal 5-year-old child. There's no evidence of that. We only have, on the direct case, the petitioner provides 2 instances in which they observe a child. One.
No, go ahead. I'm going to ask you about the medical records reflecting additional periods. I understand the two periods by the Department of Social Services, Department of Human Services, but there's medical records and evidence as well.
Yes.
That seem to reflect more, but go ahead. I'll let you start with the 2 instances.
Sure. Well, with respect to the 2 instances, the first incident was a day in September. It was a beautiful day. This 5-year-old child had been cooped up all day long at the Department of Services offices. And that can't be a pleasant experience for any person, let alone a 5-year-old child. So to say that observing her then later in the day after sitting in the offices all day, running around, because it was a beautiful September day, is evidence that the child has behavioral issues is really just, without anything more, it's just conclusory. And I would say that in that situation too, there was evidence that the mother at some point knew that, while she was talking to the caseworker, that she did need to stop the child and directed her to stop, and when she didn't, she picked her up. And the evidence was from the caseworker herself that the child was not in fear of her mother. she's a 5-year-old child. And so I think that's something that we have to remember.
Put the child over her shoulder, but didn't hurt her child.
Correct. And I think the evidence also established that the mother and child were very strongly bonded. They've been, I understand they've been traveling together for a while.
Joined at the hip.
Joined at the hip.
What was the mom's plan to obtain secure, stable housing?
Well, I think at the time she was certainly dealing with a number of issues. She was asked to leave the first place. I don't know if that was actually the first place, but she was asked to leave the one place. And I think that may have been the primary placement for family housing. And then they contracted COVID. So I understand that she was in and out, and that may have been a concern.
What was her plan? I don't recall in the records seeing anything about my plan is to do this. I mean, she wouldn't use the funds that she received from SSI for housing. She refused to use what she claimed her own money to pay for housing. So what was her plan? As far as that's concerned, is that a factor the court needs to consider? What's your plan for this child?
It's certainly a factor.
Finding stable housing. You're homeless. You're going from one place to another. You're living in the park. You're living in lobbies of restaurants and hotels. Where's the plan for stable housing?
It's certainly a factor to consider, Your Honor, but again,
Isn't Jesus, isn't that trial basically say, or that case basically say that's a factor of neglect?
it's certainly a factor, but I would point out that in the Jesus case, there was first of all a stipulation that the mother
It's
was not.
sufficient in itself to support a finding of neglect.
Right, but I think the difference there too is that in that case, the mother had stipulated that she had been unable to secure housing for the 6 months during the time the child was in foster care.
And here it was a brief period of time that she was in this area. I mean, when she was unable to do so. She
Right,
tried and says, hey, put me on a bus to North Carolina. That's when, that sounds like that's her plan for stable housing.
Right, and she was new to the area, and she shouldn't be faulted for trying to figure out if Rochester was the place she wanted to stay. She had no family here. So she ended up here after realizing that New York City was going to work out for her.
Right.
She
tried New York, couldn't find stable housing there, no plan there either. My plan was get on the bus, come to Rochester. If that's where the bus was going to take me, that's where I'm going to get off.
Right. But again, she had a short period of time to try to find housing. Emergency housing options for a family are very limited in Rochester. She came at a time too also she contracted COVID, so she was in and out. And I understand we don't want to be having families living in the lobbies of hotels or libraries or restaurants, but we also don't want them in garage parking lots or outdoor areas. And I think it was established that to the extent she was aware of what her options were,
She was given options, she was given opportunities, she was given suggestions, and she was given funds, but she wouldn't use her funds to pay for those.
Well, so the evidence on the direct case as to the funds is really unclear that it was sufficient. Sure, she got SSI income. Nobody knew when she got it. Nobody knew whether or not the funds were enough to secure housing in the short period of time she was here. Nobody established that there was housing available at that time within her funds. And I understand, nobody really likes to say, I'm poor, but, she claims that she had sufficient funds to at least feed her child and use that funds to make sure that her child was fed. And in fact, the rolling cart that they had was all contained her daughter's belongings. But she was in town for a few weeks trying to figure that out. And if you look at the additional records that were supplied by DHS, her bank records are part of her application to DHS for emergency housing. So I think everyone has overblown how much money she actually received at that time, since her bank account was regularly deficient. So if you're saying she gets $800 a month, we don't know how much money she actually received when the money was deposited into her account, because she was always negative on her account.
I don't think anybody's intended she's well off. The items that I was thinking of in the medical records, a couple of different things. And we have incidents of aggressive behavior, some of the comments that I think Justice Greenwood or the presiding justice mentioned about the sort of threatening behavior where it's 2 a.m, she's upset in the waiting room and I'm going to shoot this place up, that kind of thing. We also have the thing with the gurney that she told the child, jump off the gurney, get off the gurney. And a staff member had to come in and make sure the child didn't fall to the floor after jumping over the rail of a gurney. The other thing that was a little bit concerning, I'd like you to comment on, is this notion that she brought the child in claiming that the child was sick, and then later contended a couple of days later, the child really wasn't sick. We just didn't have anywhere to stay that night. So that's why we did. So sort of almost using the child as an excuse because she's not able to obtain the housing. I mean, is that something that could pose an imminent danger? You talked about the standard,
Sure.
being something more severe.
I would say it doesn't pose an imminent danger. Again, the child was 5 at the time. And I think many children at that age are prone to jumping off items, jumping off of surfaces. I know my own brother that did that when he was a child. So I don't think that that in itself is concerning. You know, we can't predict the future. And again, that's a hypothetical situation. There's no evidence that the child had ever been injured from perhaps being active. And I think what really is sort of telling in that situation is the mother knew that she needed to find housing for her and her child, and she knew the hospital was a safe place while she figured out her plan. And I would like to go back to sort of this planning she had. I understand that there was evidence in the record that she was itinerant, moving around. There was also evidence in the record that prior to going to New York City, she was in South Carolina for about 1.5 years, and she left a situation because it was not good for her. And in that situation too, as she got ready to settle down, she left her child with a sister in Florida, or most of her family lives in the Florida area. So the fact that she doesn't have family here is also debilitating because she doesn't have any place to leave the child while she's looking for housing. And I would submit that 3 weeks for a person of means is not necessarily enough time for someone to find housing. And when they haven't established that there was housing available to her and within her means in that time, I don't think that's enough. And again, we have to go back to the fact that there was no injury or imminent danger of injury. Because again, I don't think a situation where the child is jumping off of a gurney really suggests that the child is an imminent harm, because she was otherwise determined to be healthy. She was well fed. She was appropriately dressed each time. And I think what it shows is the mother definitely cares for her child and is always concerned for her child's interests first. We might not like her behavior, but that's not the standard in New York. The standard in New York is the minimum degree of care. And I know a number of this court's panel was on that Justice H.M. case, and it clearly established that first you have to establish the injury or the imminent injury. That didn't happen here. The trial order of dismissal should have been granted. And again, I think there was one other point I wanted to make with respect to the imminent danger. I know that both the AFC and the DHS have suggested that the child was prone to like running off or getting injured. And again, that's just hypothetical. That's the kind of speculation that's not permitted. And I would also wanted to just address a statement made by both DHS and the AFC about the child stating she was hungry. I think they have sort of implied that to have come from the senior caseworker that visited with the child on the second instance when he saw her at the hospital. And in reviewing the record, I think that's taken out of context. It was a statement that was made by the mother during the cross-examination of the caseworker. And there's no context to that, because I could tell you right now, I'm hungry because I'm ready for lunch. And, it doesn't mean that she's always been hungry. There's nothing in the medical records indicating that starvation or hunger issues was an issue with the child. She was well cared for. There's no injury here. And I think that goes to both arguments, point 1 and 2.
Thank you so much. I understand that.
If the court does not have any questions on point 2, then I will rest on my brief on that.
No questions. Thank you.
Your Honor.
Whiteside?
Yes, Your Honor, you can hear me?
Yes, we can. Good morning.
Good morning. Mary Whiteside for the Monroe County Department of Human Services. We would submit that both at the prima facie level and under preponderance of the evidence that DHS provided proof that there was a substantial risk to this child by being, by her mother failing to provide adequate shelter for her. And that is there. Yes, there's no requirement that actual harm, that the Family Court Act does not require a child to actually be harmed in order for the court to act to protect a child. And that in this instance, it's, the counsel for the mother repeatedly says, well, that's potential, or that's possible. Well, that is, when you're assessing and when you're analyzing whether there is actual substantial risk of harm, and you don't require actual harm, then yes, you look at the circumstances that the family is in making that analysis. So we're talking about a mother and a 5-year-old child who arrive at a city in fall. Right this time of year, the weather is up and down. Nights are very cold. That's a real risk. That's a real risk of not having shelter. And the mother herself describes the child as being emotionally upset based on having to go to DHS and not having housing. And that's the, I'm speaking specifically about the incident when she's running around in the park. And I wanted to focus, on the mother's assessment of her child's emotional state in going through all of this. And the child also speaks to the caseworker, Cooley, about her feelings and her awareness that they have been kicked out of shelters and residence, places to stay because of her mother's behavior. This is a child that's fully aware of that instability that she's been dealing with for like around 2.5 years, according to the record. She's fully aware of this, and that is an incident. Her, she's 5, so that is her saying how this is affecting her emotionally. Additionally, the mother, says that she is, taking Seroquel. Seroquel has for her sleep. Seroquel is a sedating medication. So if you're out in an unsheltered place, in a non-designated shelter, and you fall asleep, who's watching your child? There's no secure area. Anyone can come in. This is a real risk that a child and a mother are at because of the circumstances. So that's not saying that that's because something didn't happen or we don't have. That doesn't say that there isn't the strong indication, the strong potential for that happening based on the circumstances of this particular family. So I disagree with the mother's counsel and with the mother that's improper for the court to make reasonable inferences based on the circumstances of this particular family. It's not an indication. I think there's kind of an intimation that this happened because she lacked housing, but she lacked housing, but she also failed to cooperate with the resources that were offered to her. Her own behaviors got her kicked out of shelters. She refused a crisis nursery placement for her daughter who, had COVID, and there was nowhere else for her daughter to safely be. So the hospital ended up admitting her. She didn't need to be admitted, but they admitted her because there was nowhere else for the daughter to be when she was sick. And she also, this is in the medical records, and the mother also refused the number to the open door mission shelter. She refused to cooperate with DHS in communicating how her SSI money was spent. The argument was never that the SSI money was completely sufficient to cover everything, but she receives some money and she has to communicate in order to fill any gaps in funding and to work with that. And she wasn't communicating. And we're dealing with a particular period in time where the weather is changing. This is not that, yes, it's a 3-week period of time that she was here in Rochester, but if you look at the history of everything, this was a long period where she was moving around. She didn't have the resources to do it. She was relying on social services when things got difficult in New York. She was on a bus, come to a bus up here. She had no plan here. And then that was when things got difficult here.
I think we understand that, Ms. Whitehead.
Okay.
Yes.
If you have any other questions, I'd be happy to take them.
I appreciate it. Thank you so much. Hold.
May it please the court, Maureen Folan from the Legal Aid Society of Rochester for the Child. I guess I'd like to start by saying that my client remains in foster care, that there is a termination of parental rights petition pending against the mother in this case. We just finished the fact-finding hearing last week, and we expect a decision by the end of the month with disposition scheduled for next month if needed.
Is the mother still here locally?
She is in the Monroe County Jail at this time, so yes.
Housing.
My understanding is that she is currently engaged in some sort of a treatment court for a criminal charge, and she's being held there, her next court date there.
How's the child doing?
She's doing very well. Her foster home is pre-adoptive. I will say I am substituting judgment for her on the TPR petition because she does love her mother and she does hope that she can return to her mother's care. But I don't think that she has knowing, voluntary, and considered judgment on that issue. And I do think she would be at imminent risk if she were to be returned to her mother's care at this point. Just In terms of what the argument we've heard today, I would offer to the court that I do think that there was evidence that my client would have been in imminent physical, mental, or emotional harm, and that she was in imminent physical, mental, and emotional harm based on her mother's actions here. In terms of staying outside and the possibility that she could be injured, there was testimony from the caseworker that when the mother told the child no for something that the child wanted, the child would run away from the mother and not listen to the mother's directions. If you're out in a physical location where you don't have doors that you can lock, where you don't have baby gates that you can put up, where you can't control where your child's running. So I do think that there was that risk. I would also offer again that the mother here did have the means for housing. She simply chose not to spend them down or to follow the rules that were given to her. This isn't a situation where we're trying to penalize somebody for their poverty. Instead, the mother was making choices and getting herself kicked out of the housing that was offered to her and putting my client at risk. So unless there's any questions, I will rest on my brief.
Very good, thank you.
Thank you.
Next is 8:11, 8:14, 8:15, 8:17, and 8:18. Judith Wade versus the County of Monroe involving, let me see, wait a minute, I made a mistake here. I made a mistake, 1 second. 8:11, 8:17, 18, 19, and 20. Sorry about how I should other two, everybody else said sit down. My first day. Thanks. All right, go ahead.
Thank you. May it please the court. Good morning. My name is Alyssa Brennan and I represent Monroe County in this appeal, or these appeals, I should say. I'm going to start with the Wade case, as it was first on today's docket. In the Wade case, the trial court on a motion to dismiss denied dismissal of 6 causes of action sounding in negligence and 1 cause of action for a violation of New York State Constitution, Article 1, Section 5. This portion of the trial court's order should be reversed.
So I have a question for you.
Yeah.
So there was a doctor or what was he, optometrist or something? Checking out on the, was there any, we don't know who employs that person, correct?
Well,
was there proof of any of that? Or is he a sheriff's deputy, county employee, civilian employee coming off the street, checking on inmates?
Your Honor, the complaint specifically refers, when it talks about the allegations of the alleged sexual conduct, it specifically refers to the doctor as a correctional officer. And a correctional officer is not a civilian employee. The officers who run the Monroe County Jail are deputies. I did find a Western District of New York case, Lott, which I cited. It confirms that jail is the Monroe County Jail is staffed by employees of the Monroe County Sheriff. And pursuant to pursuant to the correction law 500C, the sheriff runs the jail facilities.
No, but I don't know if that answered Justice Kane's question, which is have we identified the individual? And there can't be that many optometrists that may have looked like corrections officers or something like that. I mean, the point being, I suppose, that if the complaint is inaccurate on a point, but we all know that there is a claim that exists there, they're supposed to be liberally construed. So just the fact that it says corrections officers, that shouldn't be a defaulting term in and of itself. Is that right?
Your Honor, my understanding is that on a motion to dismiss, the trial court must review the complaint and the complaint itself, not outside evidence, but has to read the words that are in the complaint. And here, definitively, the doctor is referred to as a correctional officer when talking about the specific allegations of sexual conduct.
This is a motion to dismiss, right? There hasn't been any discovery yet.
That's correct. So with respect to my first point, for the negligence causes of actions, the county has no duty as a matter of law, and the plaintiff in her opposition papers to the motion to dismiss made clear that she's not asserting the negligence causes of action under a theory of respondeat superior. Rather, the plaintiff is alleging that the county has an independent, direct duty here. And All of the cases that were cited in support of this by the plaintiff were with respect to inmate on inmate assaults. That is not the case here. It is a staff on inmate assault, and that would normally be governed by respondeat superior. But we know based on the law that the county has no respondeat superior liability for the conduct of the sheriff's staff.
Well, here's follow up on Justice Kane. Just no contention is that this person wasn't arguably not an employee of the sheriff's department. Therefore, you take it as it is in the complaint, and that's why the court below denied.
Well, Your Honor, there is case law and there's statutory law that supports that the sheriff has custody and runs the jail. That
Right, I understand that, and I guess your contention is, oh no, this optometrist or whoever it may have been is an employee of the sheriff, therefore that we're not responsible for that. But as Justice Kane indicated, there's a motion to dismiss, so that would come out in discovery, wherein we could find out that this person is a member of the sheriff's, and maybe your arguments would then be more applicable.
But here they're not just alleging that it's a civilian, they're alleging that it's specifically a correctional officer. And I think that language indicates that it is law enforcement. It is a deputy. It is a correctional officer within the jail who we know to be sheriff's deputies.
All right, I think we understand your argument with respect to that.
And moving on, I would also like to note with respect to negligence, even if it could be held that respondeat superior applied to the county in this case, we're saying that it still would not hold the county liable because the allegations concern actions that were outside the scope of employment. Sexual conduct is outside the scope of employment. With respect to my third point, the claim under Constitution, Article 1, Section 5, the court's decision and order recognized that the county's duty to provide and maintain the jail is distinguishable from the sheriff's duty to receive and safely keep prisoners in a jail over which the sheriff has custody. Notwithstanding this, the court's holding relies on plaintiff's allegation that the county failed to protect the safety of inmates from reasonably foreseeable acts of sexual abuse. Again, that language, safety, the court had just cited to statutory and case law that said the sheriff has to safely keep the inmates. And then the court says in the next paragraph, well, the plaintiff says that the county has to protect the safety, but that's not the law. Just because the plaintiff alleges it doesn't mean that that's what the law says. And here the law says that there is no duty for the county to receive and safely keep the prisoners in the jail. That is the sheriff's duty.
The county's responsible for the building.
That is correct.
Could the complaint be read in such a way that if there were sort of blind spots in the facility, places that no one could see, places that were private, places that had no security cameras, places where an assault, sexual assault might be more prone to occur, either between inmates or, as alleged in this case, between a corrections officer and an inmate. Could the county be held liable for something like that? First of all, in general, second of all, in this complaint?
So my understanding that if the complaint had made specific allegations that there was a dangerous defective condition in the building that caused the sexual assault, then the county could possibly be held liable, but that is not what was in fact alleged in the complaint. And this was raised in the briefing on the motion to dismiss, and the cases that the plaintiff cited in the motion papers are factually distinguishable. They all concern substandard housing. They're not relating to any alleged sexual misconduct. So I think under the circumstances of this case, just based on what is in the pleading, that the plaintiff cannot establish that there is any premises liability here. Thank you, Your Honor. I would like to note that with respect to the Platt, Killeen, Fairman, and B. Coates cases, we also argued 2 out of 3 of these same issues, and that was with respect to the negligence, because the B Coates, Platt, Killeen, Fairman cases denied dismissal of the negligence cause of action, and they also denied dismissal of the New York State Constitution, Article 1, Section 5. And so we basically asserted the same arguments. I would like to note on the record that the plaintiff named in the B Coates complaint the alleged perpetrator as a correctional officer. And again, in the Wade case, the plaintiff also named the alleged perpetrator as a correctional officer. In the Platt, Killeen, and Fairman cases, the plaintiff named the alleged perpetrators as Sergeant Wilson, Monroe County Sheriff's Sergeant Wilson. Thank you very much. If you don't have any questions, then I will rest.
We're good. Thank you.
Thank you.
Counselor, good morning.
Good morning. May it please the court. Niraj Parekh of Slater, and Schulman on behalf of the plaintiffs respondents. I would just like to address the Wade case first and take the issues in order. I believe that the county has misrepresented the allegations in the complaint. Yes, there may be a reference that it was a correctional officer doctor, but there are numerous other allegations in the complaint that describe the abuser as county employees or county agent. We don't know. We are in the process of discovery, and we're going to get that information. Judge Waldorf in the court below correctly determined what is the scope of that individual doctor.
What if this doctor is a county sheriff employee?
We don't know that. Now that, and even if it were a sheriff deputy or sheriff employee, that issue relates to the negligent hiring, retention, supervision, and training claims. That still does not relieve the county of its potential liability in negligence, which is count 1 of the complaint. And what's interesting is that the county argues we owe no duty to inmates in the jail. But then in the next breath, they say, well, no, we do owe a duty, but only for inmate on inmate injuries. That makes no sense. There's a long line of cases from the Court of Appeals, starting with Sanchez versus State, that says that the government owes a duty to protect those in its
inmate on
custody.
inmate, Villar versus county.
And that was extended to the county in Villar.
Right.
Now, the fact that Villar happened to involve inmate on inmate assault does not mean that the county is absolved from liability from reasonably foreseeable harms and risks. And I will also point out in the most recent Court of Appeals decision in Weiss Broadmoor versus Cayuga County, which we cited in our opposition brief, the Court of Appeals extended that reasoning from Sanchez and cited it. And it says that, we have consistently recognized that the government owes a duty of care to safeguard those in its custody, including incarcerated persons.
That was like a foster care situation, right?
It did involve a foster care issue, but the principles were the exact same. And the court said the principal rationale for recognizing this duty of care is that the person is in the government's custody. And
Right,
the
but
court,
we're arguing that it's in the sheriff's custody, not the county's custody. So how do you get to that?
so we understand that the inmates are in the county's custody, but the sheriff has the duty to the day-to-day oversight over the jail. And the Weiss Broadmoor case makes explicit that we also do not consider the distinction between physical and legal custody compelling in light of the negligence alleged. And that's the same issue here. So the county does owe a duty
to extend Weisbrod to this situation.
Excuse me?
You're asking us to extend Weisbrod possibly to this situation.
We believe that Weisbrod applies to this situation, and I don't think it needs any extension because it is reaffirming the principles that had previously been laid down by the Court of Appeals and adopted and cited by the court below as well. The county does owe a duty to protect inmates from reasonably foreseeable harm. We have alleged that claim here. We will find out more in discovery, and it would be premature to dismiss it on the basis that the county owes no duty at all to inmates in its custody in the county jail. Or if it does owe a duty, it's arbitrarily limited only to inmate on inmate assaults. And in fact, other cases have even extended the Sanchez and Villar line of cases to a spider bite. So they have a duty to protect inmates from other inmates, from spiders, from injury on the premises, because there's also county law, section 217, which says that the county shall maintain the county jails. Yet they're not liable to the extent that an inmate is injured by somebody working at the jail. Now, even if the abuser may have been a sheriff's deputy, that still does not relieve the county, because there are questions as to what the county knew. Were there county employees that could have stopped it? Were there county employees that witnessed it? And we've alleged this, and these are all the part of the reasons that the court below sustained these claims and allowed them to continue at this,
Because you need
motion to
discovery.
this stage. Exactly.
What are your contentions with respect to the other matters, other cases?
So with the other cases, the only real difference was that the lower court did dismiss the negligent hiring, retention, training, and supervision causes of action. And the reason was, I understand it, was because unlike in the Wade case where it's unclear, is this a county employee or not? In those cases, the alleged abuser, perpetrator, was alleged to be a correction officer. So the court below found no reason to allow a negligent hiring, retention, supervision claim to continue, but it did sustain and allow the negligence claim to continue for the reasons I just discussed. And the same with the constitutional claims across all of these cases. They are not mutually exclusive, and that's what the law says. And their arguments really on the constitutional claim, as well as the negligence claim, are really just repeating themselves. I'd also like to point out that there is actually a sixth case where they did not appeal, that did, and more specifically did allege that it was a county employee. So they acknowledge that there is a duty here if it's a county employee. They acknowledge that there is potential negligence and that there is potentially a constitutional violation. So it would be premature to, and improper as a matter of law, to overturn the denial of the motion to dismiss.
It's not acknowledging it in this record. You're saying this other case. That's not.
It's not in this record. I am just informing the court of that too. And then I would also just like to point out that we've addressed all of these issues in our opposition. The county did not submit a reply. And so I just wanted the court to be aware of that as well.
Thank you very much.
Unless the court has any more questions, yeah.
Thank you. Have a good day. 813, Wolf versus JTEKT Corporation. Ms. Martin, good morning.
Good morning. Good morning. May it please the court. I'm Kathleen Martin here on behalf of the defendant, JTEK Corporation. It's our position that the trial court erred in denying our motion to dismiss, which stemmed from the trial court granting plaintiffs 240-day extensions of time to serve the complaint. As is detailed in our brief, we believe that the Court of Appeals decision in Leader is controlling. Under CPLR 306B, the plaintiff had.
But you're only appealing from the order that denied it to dismiss a complaint, correct? That's
Yes.
However, in your brief, you address the court's earlier determinations to grant the plaintiffs the extensions, correct?
Yes, we moved to dismiss because it was our position that it was a jurisdictional issue, that those extensions should have never been given in the first place.
But that's what you argue in your brief, but you didn't appeal from those.
We did not. Those were granted ex parte. We were never served with those. We did not appeal for those. We never appeared in those two motions.
Never appeared, but there were notice of motions, right, that were made? Expert.
We were not, they were notice of motions on ex parte. We were never served. We had no notice of those motions ever occurring and no notice of those two orders being granted.
Those are non-final orders in any event.
Yes. Under CPLR 306B, the plaintiffs can show good cause or interest of justice to obtain the extension of time to serve. And under the Court of Appeals decision in Leader, multiple law office failures do not satisfy the good cause standard needed to obtain those extensions of time to serve. Here in the first motion, plaintiffs, according to their brief, it wasn't before the trial court in their explanation, but according to their brief, they gave the complaint to a process server. This is a foreign corporation. Minimal due diligence by an attorney would have known.
And you're claiming that you could have looked at the Department of State records and, but they didn't take that step, and they're claiming that's law office failure then? A factor in law office failure?
Yes, and under the ethical rules of practice, you have an obligation to, as the attorney, to monitor the non-attorneys that you hire. Then they realize, oh, we can't serve the Secretary of State. So then they seek a second extension of time and say,
Is this the first time you're making these arguments then? They weren't made below?
they were never made because we were never, oh, no. I motion to dismiss.
Dismissed, though.
Yes, we made these arguments, Your Honor, but if you read the court's written decision, the court never addressed any of this or the controlling authority of Leader.
And didn't the court then basically, by not addressing those, basically say that we already ruled on those? I gave those extensions before there was no contention here.
And that's all you're arguing here. It's about the extension.
No, we moved to dismiss the complaint saying there's no personal jurisdiction.
That's what you're
Right.
going to do. but
Lack
then
of personal jurisdiction.
what You're arguing is about the extensions.
Yeah, they never should have been granted in the first place. And had they were granted in error, and had they never been granted, they never could have served my client with the complaint almost 4 years after this action accrued. And when you get into, and that's what I think the key issue is, when you read the Court of Appeals determination in Leader, all office failure does not constitute the good cause argument. And then when you get to the interest of justice, that is a little bit more flexible, but this court in Mulder says law office failure does not satisfy the interest of justice. And then you also need to look at prejudice. And the Court of Appeals, it's one of the last substantive sentences of that decision, says finally defendants had no notice of plaintiff's claims for nearly 3 years after their accrual, leading to an inference of substantial prejudice. The notice my client received is even longer than what occurred in Leader. There's an inference of substantial prejudice. So when you apply the controlling case law, those extensions never should have been made in the first place. And when you look at the reasons counsel gave in each of the motions, they basically were intimating these are circumstances beyond our control, which was not the truth. In the second extension, they said, well, JTAC moved, the address changed. It did not. They were at their current address since 2020 for over 3 years before they ever attempted service. They had a letter in their file giving them the correct address when they attempted service. They didn't do any due diligence. And yet my client receives notice of this complaint more than 4 years after the accrual.
Okay.
And that's not prejudice. Under the controlling authority of Leader, there's no other case where this is as egregious as what occurred to my client. There's none. The only one that's akin to it is Leader. And the prejudice to my client is beyond it. And the Court of Appeals said it's the inference of substantial prejudice.
I think you understand.
Go ahead.
Oh, I just wanted to address
I was just reading, I think.
Yeah. For the first time in their brief, they brought up that we should have moved under CPLR 5015. This was never brought up before the trial court, claiming that we should have made a motion to vacate. There's a reason why you have to preserve things for in the trial court, and this never was, and we could have addressed that. And I just want to point out there's no time limit to it. So if this court believes we should have moved under 5015, we can go back to the trial court and do that now. And we're just going to end up back here because
You could have moved back when you made your motion to dismiss too at the same time, right?
had plaintiff raised it, we could have amended our motion and done it at that time. But if we're just doing form over function, I can still make that
Couldn't
motion.
you have said, well, geez, now I got these, how do we get here? I got these extensions, and And I can move to vacate these. I was,
We moved to dismiss under the personal jurisdiction that they
Right.
never should have. But had plaintiff raised that in opposition to our motion and said, and this is why you're supposed to raise things in the trial court. We could have simply amended our motion at the time. I can make that motion now. It's timely. I could have amended my motion at that time and said, I'm also seeking the relief under 5015. But they never raised it. You can't come to the appellate court and raise it now. If this court says I should have, I'll go back to the trial court, I'll do it. The same very legal arguments that are in front of this court will be raised, and it's very likely we will come back here again on the same legal arguments because leader is controlling.
very good.
Thank you, Your Honor.
No, I think, do you have anything else?
No, that's it. Thank you.
Thank you. Mr. Collins?
Good morning, Your Honors. Please the court. John Collins on behalf of the plaintiffs in this case. Supreme Court's order denying JTech Corporation's motion to dismiss plaintiff's complaint upon the ground that the court lacked personal jurisdiction over JTech should be affirmed. The summons complaint were duly served upon the defendant within the extended deadline granted by the Supreme Court in its extension of
Deadlines, again, those were never, nobody objected to those, correct? And they're not final orders, correct? So is any of this appealable?
an appeal. This court is held in the case of Rexford is the defendant, Bradley versus Rexcoat rather, held that you can't take an appeal from an ex parte order extending the time to effect service. What you have to do is make a motion to vacate the order that was granted on an ex parte basis. And then if you deemed yourself aggrieved by the result of that motion, appeal from the order resolving it. Here.
That wasn't done.
That wasn't done.
So this.
So what the defendant did instead, Your Honors, is move to dismiss on the grounds that there was no personal jurisdiction. And it raised two arguments. One, that the extensions should not have been granted, but there was no motion to vacate the orders. And two, that plaintiff didn't properly allege jurisdictional facts. JTech has not pursued that second argument on appeal, which is really the what the trial judge focused on in its order in this case, which was generated by the court, not by counsel. So we're left with two extant orders extending the time to effect service
That aren't appealable.
that are not on appeal and couldn't have been directly appealed. They could only have been appealed on a motion to vacate.
So based on your presentation here, even though you started out saying it should be affirmed, really your position is should be dismissed.
Well, I think the order should be affirmed because the order denied the motion, which was brought solely under 3211(8), which is lack of personal jurisdiction.
You're really saying that the appeal should be dismissed, aren't you, based on what you just read?
Well, I guess the argument could be made, or the tack taken, that the appeal should be dismissed insofar as it implicitly seeks to appeal from two ex parte orders because no appeal lies, but the order should be affirmed to the extent it otherwise denied the motion under 3211(a)(8).
But how do we do that if it's not an appealable order?
Well, I guess you'd have to somehow split it and say parts appealable and parts not, because there was a valid order made under 3211(a)(8) addressed to the purported lack of allegations regarding jurisdictional facts. That has not even been pursued on this appeal, but that part of the order certainly is affirmable, I would say, rather than subject to dismissal. But if I could go on, even in the event the propriety of the extension orders were before this court, the trial court's resolution should not be disturbed. The standard of review under CPLR 306B extensions is, did the trial court abuse its discretion? And here I submit that it didn't. A plaintiff has to exercise reasonable diligence to effect service, not perfect diligence. And I think here the diligence was reasonable because it's,
They sent it to the wrong address.
they sent it to the wrong address.
Apparently you had information that in your files that showed what the proper address was. Maybe because there was two listed on the website or in some letterhead, it was an error. Is that an oversight though? I think leader indicates that sometimes an oversight might be.
Yeah, I think it is nothing more than an oversight. Yes, leader held that the court under a 306B motion can forgive mistake, confusion, or oversight. And I think here perhaps it would be confusion because the letter to which Your Honor referred is at page 74 of the record, and it was sent by the workers' compensation carrier for one of the affiliate defendants of JTEC, which is a Japanese corporation. And this insurance carrier addressed the letter to JTEC in Japan at two separate addresses, Nagoya City, which is the one we used, and Kariya City, to which it had evidently moved in 2020, according to Defense Counsel. Again, there are two addresses there. By all appearances, JTEC could have been reached, served at either of them, according to the letter from the affiliate corporation's own insurer. And so,
isn't there an issue too, according to the Hague Convention, that situations such as this, it has to be transcribed into Japanese? You're sending it. Somebody's opening the mail, and it's whether it's transcribed or not properly. They're gonna put it in a pile and send it off to someone.
The pleadings certainly have to be translated. And we affected that.
Well, was this letter transcribed or no? I mean, if I don't understand English and I'm sitting there, my duty is to open the mail, and it's in English. And what do I do with this? Another piece of junk mail from the U.S.
Well, I don't think that that inference could fairly be drawn here because JTEC, as we established through some citation to some.
I guess I'm just getting to the argument of reasonable diligence.
Yes, well, that letter was sent not by us because we did have the summons and complaint translated. That letter was sent by the insurance carrier for one of JTEC's affiliates, and certainly.
But you're relying on that to send your summons and complaint.
Our information was that they were still located in Nagoya City. Apparently, they had moved a couple years before, possibly 3 years before. But because it is a Japanese corporation, I don't think it's a lack of reasonable diligence to not be aware of an address change that, in that time frame. And certainly the insurer for the defendant corporation's own affiliate thought it was at both addresses. And the letter, I was going to say, Your Honor, that this is a corporation that has sold billions of dollars worth of high-tech equipment in the U.S. since 2006, according to the federal case we cited.
Right.
So presumably, because they have American affiliates who handle the sales and distribution of goods here, they have the ability to communicate from their Japanese main headquarters with affiliates in the United States. Things get done in English, presumably. And beyond that, other than saying, well, we were prejudiced, JTEC has interposed no proof establishing any such prejudice. They haven't interposed any proof that, the letter was not read and understandable by someone at the Japanese headquarters. They have not interposed any proof that they no longer have access to relevant records or knowledgeable witnesses. In that regard, I note this involves a machine that was distributed in 2019. It's not like one of those products liability cases where you're dealing with a 35-year-old piece of equipment. So I think there's no prejudice because, their own affiliates were timely served in the US, and presumably they in fact told the Japanese corporation, hey, we got sued and you're listed too, beyond what was stated in the insurer's letter. But because their affiliates, are in America, know what's going on, knew about the case, had every opportunity and motivation to tell the Japanese corporation, we got sued, you got sued too, expect a summons and complaint. There's no prejudice here. And again, the standard of review is abuse of discretion. So even if the propriety of these extension orders is before this court, I don't think it could be said that the trial judge abused his discretion in granting those extensions under these particular facts.
Thank you, Mr. Collins.
No. 8:14 and 8:15. Shangui B versus Sayeg and Sayeg. We're both on video.
Good morning, Your Honors. Can you hear me?
Morning, Ms. Hager. How are you?
I'm good. How are you?
I think we just delved into the afternoon, so good afternoon.
Yes.
That's okay. All right, whenever you're ready.
Okay, I'll start with my first appeal. The first appeal is an appeal of the denial of our motion to dismiss that was brought after the plaintiff failed yet again to file opposing papers in conformance with the deadline. And multiple adjournments had been granted up until that point, and the court had also stated that it would grant no further adjournments. It is our position that the court abused its discretion in not granting our motion to dismiss in October 2023. At that point in time, the court had already permitted 9 adjournments of the summary judgment motion, had, as I said, articulated that there would be no further adjournments allowed. The summary judgment.
What about that? Let's decide things on the merits. What about that? Argument made here.
It's our position is that we had 120 days to bring a motion for summary judgment. In this case, they had over a year and a half to oppose a summary judgment motion. The length of time here became unreasonably prolonged, where the case was just held in the summary judgment phase for almost 2 years.
Well, does the record show that your side agreed to some of these adjournments too?
Your Honor, we did agree to some of these adjournments. We did provide the common courtesy when the plaintiff represented he had a busy schedule and was not able to conform with the deadlines. He would make continually last-minute requests for an adjournment, and the court eventually sanctioned him for those last-minute adjournments. And then we objected to any further adjournments. The court said no further adjournments will be granted, and the plaintiff was supposed to file papers on a given day. And again, the court actually contacted the plaintiff to ask, are your papers forthcoming today? And he responded this afternoon, and they didn't show up yet again. At a certain point, this is becoming prejudicial to the defendants as they have a perpetually pending case against them held in limbo in the summary judgment phase. And as I said, a year and a half, that's actually quite significant amount of time.
Right, but you're not arguing that just because the court said no further adjournments, that's not the abuse of discretion. You're saying the year and a half and the whole totality is the abuse of discretion, correct?
The whole totality with the multiple adjournments and the court stating there will be no final adjournments as big factors in the abuse of discretion.
Okay. What about 8:15?
Oh, our motion for summary judgment, as we know the outcome, the plaintiff did eventually provide opposing papers for our summary judgment motion, but they're insufficient. First, we met our burden. We provided the requisite affidavit that's detailed, specific, and factual in nature. The burden shifted to the plaintiff, but the plaintiff failed to meet their burden because they did not address the expert did not address significant and critical facts that our doctors relied on in their decision-making. I'll take one doctor at a time. If you look at Dr. Tuchani, he saw this plaintiff on only one date, June 22nd, when she was in the hospital. He was involved in the decision to discharge her from the hospital that day. The plaintiff's expert states in conclusory fashion that she should not have been discharged on that date, and the plaintiff's expert points to a non-stress test that showed 2 late decelerations. However, the plaintiff's expert then completely ignores and does not address the fact that a standard of care biophysical profile was subsequently done, which confirmed that the fetus was healthy. It scored an 8 out of 10. It lost 2 points for the non-stress test, but it scored an 8 out of 8 for the issues of normal fetal breathing, normal fetal muscle tone, normal fetal movement, and the amniotic fluid is fine. This is not a fetus that's in distress. I'm sorry.
Counsel, I'm taking a look, and maybe this is what you're referring to, but correct me if I'm wrong. I'm looking at page 445 of the record, which is the discharge summary from Sisters Hospital on the 22nd. And it talks about how on NST, the baby had a category 1 tracing. And I know Dr. Saye had already, is it Saye? Saye, is that?
That's Tuchani on the 22nd.
No, I know, but
Oh,
Dr.
sorry.
Saye gave testimony about that and said that that was a good finding, a normal finding.
That's correct. It's a category 1 is a normal tracing.
All right, except for the 2 decelerations that appeared late in origin. The thing that strikes me is if you go down 2 sentences, it then says an NST. So at that point, they weren't discharged, and the patient wasn't discharged, the mother. And then an NST a few hours later showed very few contractions and a category 1 tracing. She symptomatically felt improved and requested discharge. So that was the fact after the 2 decelerations, it looked like they waited, did it again in the afternoon, and that it was normal. Is that your reading of it?
That is absolutely my reading of it. And
right. Is that what plaintiff's expert failed to address?
Exactly. The plaintiff nowhere addresses the second non-stress test that you just referred to that was a category 1 tracing and perfectly normal and reassuring. Okay, I will turn to Dr. Sayag argument. It's the same argument, it's a different date. The plaintiff's expert is focused on the last date that Dr. Sayag saw the plaintiff at an office visit on June 24th. And similarly, the plaintiff's expert is not addressing the very critical facts that informed Dr. Sayag's decision to not send the plaintiff to the hospital on this date. Dr. Sayag performs a non-stress test that day. He could not say it was reactive or non-reactive. He scored it a 0, but he followed it up with the standard of care biophysical profile test, which scored an 8 out of 10. It lost the 2 points for the non-stress test, but it was an 8 out of 8 when you look at all those elements of fetal health. This fetus is not in distress on this date. And the plaintiff's expert also falls back to rely on that June 22nd non-stress test that showed 2 late decelerations. And once again, does not address, as with Dr. Chuchani, did not address that there was a subsequent normal biophysical profile, as well as a subsequent non-stress test that was perfectly normal.
What about their general argument that outpatient was inappropriate here and the monitoring could have been done that would have addressed this situation? Why isn't that enough, in the papers?
Well, first of all, the plaintiff's expert doesn't address Dr. Lawler, saw the patient in a maternal fetal medicine specialist consult on June 21st. And he, as the specialist, said that it is appropriate to discharge this plaintiff and expectantly manage her until 37 weeks. At this time, she's at 34 weeks and a few days, and expectantly manage her until that time. So first of all, Dr. Lawler has given his opinion that it's appropriate to discharge. And that continues. There's nothing that's changing in the plaintiff's presentation that's telling anyone that this is a fetus in distress, that she has mild preeclampsia, but there's nothing that's developing further, and her blood pressure is correct. It's still appropriate to expectantly manage her till 37 weeks. There are other facts that the plaintiff's expert ignores too, especially with respect to Dr. Sayag as well, that the plaintiff's blood pressure was normal on June 24th when he saw her. The fetal heart rate was normal. There was no sign of preterm labor. It was appropriate to continue the expectant management through, this was a preterm plaintiff, to expectantly manage her through 37 weeks.
So it's your position then that these failures would have warranted your client's receiving summary judgment?
It's my position that the plaintiff's expert has glaringly omitted important facts that formed the basis of our doctor's opinions and cannot raise a triable issue of fact with those omissions. And I would even point out in the plaintiff's responding brief, they do not dispute that these facts are not addressed by their plaintiff's expert. They create a distraction and say, our expert is a medical doctor, defense attorney is not. So let's go with our expert's analysis of everything. But even if their expert is a medical doctor and qualified to give an opinion, the opinion has to be legally sufficient and address the critical pertinent facts that our doctors addressed in their affidavits.
Anything else?
I'll rely on my papers for proximate cause unless anyone has any questions, and otherwise I'll rest on my papers.
Doesn't look like there's any other questions. Thank you.
Thank you.
Mr. Block?
Good afternoon, Your Honors. Can you hear me?
Yes, we can. Good afternoon.
May it please the court, Joshua Block for the plaintiffs. We believe that the order should be affirmed because Judge Licata properly exercised his discretion in granting the adjournment and properly denied summary judgment. I'll start with the issues in order, starting with the adjournment. Firstly, as Your Honors alluded to, I'd like to go a little bit more into the timeline. And that's that the defense consented to the adjournment through April 2023. So that's a full year of the period that they're discussing. Then they said they would move to dismiss, but the court granted the adjournment, and their first actual objection wasn't until July 2023. So what we actually have is about 6 months where the defense objected to the delays. However, more important is that Judge Licata took the delays very seriously. As defense counsel alluded to, there was a sanction. And in addition, and probably more importantly, there was the in-camera hearing that the judge held. And it was after the in-camera hearing that he exercised his discretion, which is not something that is ordinarily set aside and cannot be set aside here, given the in-camera hearing review means that the record is really kind of insufficient to know everything that the judge considered, since we don't know what happened in camera. In this case, especially, affirming Judge Licata's use of his discretion is especially important, given the public policy favoring resolution of cases on the merits, which is something that Judge Licata specifically referenced, as well as the lack of prejudice. This is a 2016 medical malpractice case. A couple of months between then and now, we're almost 10 years in, we're 9 years in. That's not delay, especially given the fact that the reason I mentioned it's a medical malpractice case is what this case depends on is it depends primarily on the medical records, which aren't changing no matter how much time. If you honestly have no questions as to that issue, I'll move to the summary judgment issues.
Yeah, let me ask you very specifically so we can focus on this a little bit. Why is it is there anywhere in the record, and maybe I missed it, you can point it out, that your expert pointed out that the reliance by the doctor to discharge the patient was inappropriate?
Yes. So if I...
It is in the record? Where is that?
Yeah, so I believe it's paragraphs 25 through 29. It's 90 pages, I'm sorry, 998 through 1001. And he discusses them, and he specifically says, if you'll give me one moment to look through it, because I didn't have this highlight, to be honest. He talks about how the first day on the June 20, on June 22nd, the patient should not have been discharged. And on June 24th, specifically, how she should have been readmitted. And I'm not pulling it up. I know that it specifically mentions that in terms of what the standard of care is and how it was deviated from and how that was the approximate cause.
Isn't that kind of conclusory? I mean, in 25, they don't really distinguish between the two doctors, just saying basically, that what they did was a violation of the standard of care, a deviation.
Well, we know that, so if I could be more specific, on June 22nd, that is Dr. Ciucciani. And on that day, Dr. Ciucciani deviated from the standard of care by discharging her primarily because of the large uterine fibroid.
Wasn't there basis for they consulted with the expert, I think his name was Dr. Lawler, who indicated that it was permissible to discharge her as long as she has a follow-up care in place. And also, concerning Dr. Lawler, it didn't seem as though the plaintiff's expert challenged that, but Dr. Lawler made a motion for summary judgment, and that was granted, and I don't think it was opposed at all.
Right. So we're not here for Dr. Lawler. I believe that Dr. Lawler was the day before. And specifically what we were saying as to these doctors is that given their specific knowledge, they deviated from the standard of care. And
but they went to take that next step further and spoke to Dr. Lawler and got he was
right.
more of an expert.
Right. But given the facts known to these doctors, specifically
they had Dr. Lawler's facts as well. Dr. Lawler's opinion as one of their facts. And they're making their determination.
Correct. Obviously, the determination has to be on the totality of the circumstances, given everything that was known to them, what was known to Dr. Lawler, as well as known to these specific doctors. And it is our doctor's opinion, our expert's opinion, that what they knew resulted in a deviation from the standard of care.
I don't think it challenged Dr. Lawler's opinion at all.
No, we did not.
Okay. So Counselor, and as the presiding justice has pointed out, Dr. Lawler is the specialist. Dr. Ciucciani is relying on Dr. Lawler's expertise. And a lot of the factors that your expert, in fact, nearly all the factors that your expert points out, that what Dr. Ciucciani should have considered were considered by Dr. Lawler, is in Dr. Lawler's report. And then Dr. Lawler gets out, the specialist. And of course, Dr. Ciucciani relies on Dr. Lawler. So what I did when I saw that is I looked and said, is there anything else? Is there anything else that Dr. Ciucciani could have relied on? And the only thing I could come up with was what I asked opposing counsel about, which are these decelerations and the NST the following morning. Because now this is the morning after Dr. Lawler's report. Dr. Lawler was on the 21st. This is the 22nd, date of discharge. We have the decelerations. And I said, well, if Dr. Ciucciani sees these decelerations that Dr. Lawler didn't know about, goodness, maybe Dr. Ciucciani shouldn't have discharged. But then they test it again. They test again in the afternoon and everything's okay. So that's why I asked opposing counsel, was that addressed by the expert? And doesn't your expert have to then address that and say, no, that should have been insufficient for whatever reason, but I didn't see that in your report.
So I think you're right in that the three main things that Dr. Ciucciani should have looked at on June 22nd, the uterine fibroid known by Dr. Lawler, the preeclampsia also known, as well as the fetal heart tracings that you're referencing at 9:50 and 10 o'clock. And what defense counsel has essentially said is there's other stuff that came afterwards that negates that. But that's not any doctor's opinion. That's just defense counsel's opinion. They didn't even submit an expert opinion on reply to contradict what our expert says. So it's not
I'm looking at Dr. Saez's testimony. It's pages 797, 798, and he's talking about the decelerations and how the decelerations had resolved. That essentially, the question is, it's my understanding that what you're saying is the two late decels on the NST were of no significance. Is that accurate? And he says, correct. So it's not attorney opinion. That's what Dr. Saez said. And so now you have to turn back and say, oh, okay, what does plaintiff's expert say? And my question to you is the answer to that question, nothing?
His opinion is that there should have been continuing monitoring. I do not believe, and I think Your Honor is correct on this, that he does not go through all this other stuff that's been raised by defense counsel. But what he does do is he says, these are the facts that I find significant, and based on those facts and based on the standard of care, as I understand it, as I've laid out, there is the deviation. So I think that leaves that's a battle of the experts at worst. At worst, assuming that this was discussed in the deposition to the extent that could be considered enough to meet the burden, that just results in a tribal issue of fact, Your Honor.
Anything else? Go ahead.
And then as to the improperly failing to differentiate, I would also add that wasn't really raised below. That's not preserved for appellate review. But if you look at the different paragraphs in context, we know that, as I started to say initially, June 22nd is Dr. Chuchani. June 24th is Dr. Syed. So the malpractice that occurs on June 22nd is Dr. Chuchani. The malpractice that occurs on the 24th is Dr. Syed. And both of them are the group because they both work for the same group. If there's no other questions, I'll rest on my brief.
Thank you very much, Mr. Black.
Thank you.
(816) and 816.1, Kathleen Gumkowski versus Thomas Schwab, MD et al. Britt.
Morning.
Good morning.
Good afternoon.
Good afternoon, sorry.
Infectious.